Good evening, everyone. I'm Jeffrey Hunt from the College of Southern Maryland. I am the Endowed Faculty of Innovation at the college, working with the Velocity Center here with students in STEM areas. I'd like to welcome you tonight to our presentation here of Innovation at the Velocity Center. This evening, we are fortunate to have James Brinkley II with us, who is going to come and talk to us about the importance of intellectual property. So please, if you have questions during the presentation, take and place them in the chat. I'll monitor those. We'll try to get to those after the presentation is over. But right now, I would like to ask James, if you would please come over and speak to us for the moment. And then afterward, maybe we'll have a couple of questions we can ask. So thank you very much. All right.
Thanks, Jeff. As Jeff said, my name is James Brinkley. I'm the founder and CEO at IPGen, where we're building a platform and building tools to ease the processes of IP for anyone involved. It goes from entrepreneurs and startups to universities to law firms and things of that nature. So anyone who touches IP, that's who we're gearing our products towards. But today we're going to speak generally about IP and how it works within entrepreneurship. So the first question you might be asking yourself is, what is intellectual property? And for sure, I'll be calling it IP throughout this presentation. Intellectual property is a category of intangible property that refers to the creations of the mind, such as inventions, designs, and symbols. This is kind of contrary to real property. I like to say, we all know what real property is. Houses and things of that nature that you can, you can touch and feel. These properties are the intangible ones that you can't touch and feel, but we still own as we build things through our creative minds. There are different types of IP. We have copyrights, we have patents, we have trademarks. Trademarks and service marks, I'll go into those later, but they're similar. And then we have trade secrets that we'll go into today. First, we'll start with copyrights, where it originates. It's to promote the progress of science and useful arts by securing for limited time to authors and inventors the exclusive right to their respective writings and discoveries. What this means is that for a limited period of time, you're able to have that ownership of these things. And we'll go into the different things that you can copyright, things that you can't copyright, so as you move forward in your businesses. IP, IP is a great thing for startups, for large companies, because, we always want to protect, what we're thinking about, what we're building, so no one else can take it and run with it themselves. So what is a copyright? Copyrights protect the original works of authorships that are fixed in a tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated directly or with the aid of a machine or device. And the key word here, or key words, is fixed in a tangible medium. So that's as soon as we put pen to paper, as soon as we put paintbrush to easel, as soon as we, put the code in the software, onto the computer, you have copyright protection from that point. Different works of authorship, and these are examples of things that you can get copyright protection from. We have books, literary works, sound recordings, website content, software, paintings and motion pictures. So authorship in the workplace. I'm an employee author. The employer will own if created in the line and scope of employment. So if you're working for someone and you create something, most times we have an employment agreement where it's lined out, it's stated to, who owns what when you build it. You have one type of agreement where if you own the company's time, if you're using their tools and materials, that they will own, whatever you build. And then some agreements will say, while you're working with us, anything you own is owned by us. And so a quick little story, when I was working for IBM, I had the latter agreement in my contract. So when I was thinking about IPGen and all the things that it could do, I had to, leave my position at IBM to take a chance, to take a risk to further what I believe, could be great moving forward. And I never looked back, and I'm glad I did it. But, sometimes you have to do that to continue on what you want to build. So we have independent contractor author. What this is, unless otherwise stated in writing, independent contractors own the rights that they create. Similar to, and this is a sticky, kind of a thin line between independent contractors and employees. There are certain things, certain parameters that will lean one way or the other. There have been plenty of arguments in court back and forth. And the big one is with like Uber and Uber drivers, or Lyft or Lyft drivers, if they're employees or if they're independent contractors. So there's a thin line with that. You want to make sure that you have that, drawn out when you engage as an independent contractor or as an employee, and make sure before you start building and creating things that you want to keep for yourself, make sure you look at those agreements that you have with your employer to make sure that you will be the one that owns those things. And that goes for all IP, not just copyrights. So what's not protected from copyright protection? Ideas, procedures, processes, systems. These things are protected by different types of IP, which we'll go through soon. Some of these are protected by patents, some may be protected by trademarks, but these things cannot be protected by copyright. So what rights are granted with a copyright? So you have the exclusive right to reproduce, prepare derivative works, distribute copies, publicly perform, and publicly display. So these are the rights that you have protected when you get copyright protection. You have to police these things yourself. The office isn't going to, if someone is infringing on your copyright, they're not going to call you and say, hey, this person is using whatever you did. You have to make sure that you're vigilant and keeping an eye on what's going on to make sure that your things aren't infringed. Larger companies have departments for this, where that's all they do is police the internet, police whatever's going on in their industry to make sure that these things aren't happening. An example of that is, I know a lot of people use YouTube or Facebook or Instagram, and when you're loading a video with a song, sometimes you can't use that song because the author or the copyright holder didn't approve of that for that platform. So you have to be careful about what you do with that. You don't want to be hit. There was a case recently of a TikToker who used a song, and he earned, I believe, around $700,000 from views and whatever, however he monetized it. And Sony came back and sued him. And so he made, I think, $700,000. He owed Sony, it's between 800 and 1 million. So he lost in that, in that scenario. Now, from the following he gained, he may still be okay, but that's a thing where he could have went to the song, went to the author, went to the copyright holder, and created a licensing agreement or something where he wouldn't be in this hole now. So, you can do those things as well. So copyright registration. Like I said earlier, the moment you put pen to paper, the moment you put it in a tangible medium, you have copyright protection. Federal registration is voluntary. It's only required to pursue certain legal remedies, and this is similar in trademark as well. So the big thing about this is putting people on notice that you own that copyright. So if I use something that someone else already, produced, and they sue me, but it's not federally registered, it can only get a certain amount of damages from me. But if it's federally registered, then they put the world or the country on notice that, I'm the copyright holder. You can't use this. And so if you do, it's an understanding that you should have known that someone owned this copyright. And so you're able to get higher legal remedies from that. So how long do copyrights last? They last the author's lifespan plus 70 years. If it's a work made for hire, like I mentioned before, or if it's something that's anonymous that you don't know, who created this, at that point it's 95 years from first publication or 120 years from creation, whichever comes first. And so, copyright lasts pretty long. So if it's something valuable, you want to protect it. I believe there's some songs, some of the big ones, I think, like Sonny Bono, and people like that who have created things a while ago. I know Mickey Mouse has recently, I believe, went back into the public domain from all the years from when they first created it. So things do come back into the public domain, but they had all those years to capitalize and kind of monopolize that thing. Now, there's also something called fair use, that this is where you can use the copyright material for a limited purpose. And a lot of times we see this in skits and research, universities and teaching. You want to be able to use pieces of things to teach it to others, to the next generation, to people coming up. And sometimes you have to use a piece of that information that's protected, but you have a very limited use of the things you can do from the fair use doctrine. So now we're going to move to patents. Patents are a whole different beast. Patents are expensive. Patents are time-consuming. Patents give you a great deal of protection and things that can be extremely valuable. And a lot of times, the smaller companies or the entrepreneurs are kind of kicked out of this form of protection because they don't have the capital when they're starting out to pursue patent protection. And you see a lot of times there are these companies that prey on entrepreneurs to say they'll do certain things and they don't come through, or bigger companies, if you do start doing what you're doing, they'll see that, tweak it a little bit, and then they'll run with it and make a bunch of money from something that, you'll see it later and be like, all you can do is tell your friends, I had that idea first. But, that's just the nature of the beast. It's geared more towards larger companies, towards the capitalistic society right now. And, there are things that are, being done to kind of put the little guys on an even playing field for that, So the purpose of patents is to stimulate invention and share knowledge. The point of it is you have to share with the public how to make and use this invention, and then you get protection, for a limited time to pretty much take what you have and to make, for lack of better words, to make the most money you can until it goes into the public domain. The goals of patents are to solve a problem, make improvements, and increase efficiency. So what is a patent? Most people think getting a patent allows you to do something, but the patent grants the right to exclude others from making, using, selling, or offering to sell the patented invention during the patented term. And so patent rights don't overtly give you rights to do something. It gives you rights to exclude others from doing what you're doing. And if anyone wants these slides, I can provide them to you, afterwards. If you send me an email at James at IPGen.io, I'll get those over to you if you want to copy these slides. So how do you gain rights? So the U.S. systems is the first to file. That means that usually if two people are building something similar, the first one to file the application is generally going to have the rights, to that invention. It used to be different a little while ago. We just, I say recently, but within the past few years, we moved to a first to file country. Most of the other countries are first to file. We were one of the last ones to switch over. And then there are two types of patent applications, provisional applications and non-provisional applications. The provisional applications are applications that don't get examined. Those ones are really like a placeholder, and they really help entrepreneurs because there are less requirements to file that type of application. You don't have to give as much information. You file that, and then you have a year from that date to file the non-provisional application, which is the one that gets examined by the USPTO, and that's the one that you will move during prosecution and towards grant, and that's the application that will give you the protections for the invention that you create. So inventions, they cover machine, manufacture, process, and compositions of matter. There are requirements or hurdles that you have to overcome for these protections. Your invention has to be novel or new. It has to be non-obvious, where it's not an obvious variation of multiple things that are already out there that you put together. So if they determine that it was obvious to put A, B, C, and D together, then they won't give you a patent for that. And then it has to have utility. It has to be useful for the purpose that you say. Here are a few things that cannot be patented: physical phenomena, abstract ideas, laws of nature, and theoretical plans. The term for a patent is much shorter than it is for a copyright. It's generally 20 years from the filing date, unless something really happens during the prosecution period, where they may add a few more years if it takes too long going through prosecution. And there are three types of patents: utility patents, design patents, and plant patents. Obviously, plant patents cover plants, designs cover designs, and utility covers the purpose, the kind of functions that the invention does. That's generally the patent process. You have prosecution as well, where after you file the application, that's when the prosecution phase starts. It's pretty much a negotiation between the applicant and the government and the USPTO, to where generally, they're going to reject your application, tell you why they rejected it, and then you negotiate. You file a response, you argue, or you make legal arguments, or you may change some information within your application, and then you submit that response. And you kind of want to start kind of broad, kind of wide, and chip away at it until you get narrower and narrower, where you have that broadest protection that you can get from that. So next, we're going to go to trademarks. The goal of trademarks is to provide legal protection for your brand, help guard against fraud and counterfeiting, and identify the source of goods and services. So some companies or some entrepreneurs may need copyrights. Some companies or entrepreneurs may need patents. But I always say that every company or every entrepreneur needs at least one trademark, because you need to build your brand when you begin to go to market to sell your product or to sell your service. So trademark protection is very important for that. I mentioned this earlier, trademarks and service marks. You get the same protections. Trademarks are used to identify goods and products, and service marks are used to identify services. It's just that simple. You get the same protection on both. So what are trademarks? Brand identification. They indicate the source of goods and services. So, if I'm selling a product, the consumer should know that that product came from my company. And that's the purpose of the trademark, to identify that product to be connected to my company. You distinguish goods and services from those sold by others. For example, if it's two different kinds of shampoo or two different kinds of, sodas, you want to distinguish from where those came from. Any word, phrase, symbol, design, sound, or combination thereof that identifies goods or services can be trademarked. Here are some examples that can be protected: color schemes, sounds, words, logos, the typical things that you use to distinguish yourself from other brands. So the term of ownership is a little different for trademarks than it was for copyrights and patents. Trademark protection lasts so long as there's continued use of the mark in commerce. There's exercise control over quality of goods and services, and of course, filing and payment of maintenance, docs, and fees. One thing you'll learn about IP: there's always fees and docs that need to be submitted. So trademarks, you have to keep some maintenance, docs, and fees over the life of your trademark, pretty much to let them know that you're still using it. So when do you become an owner? Trademark protection is created as soon as you start using your mark with your goods and services in commerce. And this is similar to the copyright protection that I mentioned earlier. As soon as you start doing this, you have trademark protection, but you want to federally register it to attain certain rights if you need to go after someone for a trademark infringement. Registration is not required, like I said, unless seeking certain legal remedies. Trademark types: generic, descriptive, suggestive, arbitrary, and coined and fanciful. Those are the key terms. Those are the degrees of strength of a trademark. Coined and fanciful will give you the strongest, and generic is the weakest. So that's pretty much a sum of trademarks. I had a client when I was in practice that filed for a trademark that he was using, and it got to the end of the process. It got, his trademark was granted, everything was good, but then we got an opposition from, I'll say, from one of the professional leagues, one of the professional sport leagues, that they didn't feel like my client should be allowed to have that trademark. They felt it was too similar to theirs, which, that's subjective. So, at that point, we went through an opposition, which is kind of like a trial within the government for the trademark. We settled out of court. My client got some money for it. They got to work with this professional league. And so things worked out well. And so that's one, example of how filing federally for a trademark can help you in your business. So lastly, trade secrets. We'll do a few. We have a few about trade secrets. What is it? Trade secrets is confidential business information that is generally not known to others in the trade or business that gives a company an economic advantage over its competitors. So a lot of people either patent something or either keep it as a trade secret. If it's something that's easily reverse engineered, then you want to get a patent on it. If it's something, because if someone can, if you put it out there and someone knows how you did it, they can do it, and then you don't have the protection that you thought you had. If it's something that's hard to recreate, keeping it as a trade secret might be the best protection for you because it doesn't expire. And the most known one, of course, is the Coca-Cola formula that is still a trade secret, and people have tried to copy it, but no one has gotten it. So what can it be? It could be manufacturing processes, supplier lists, computer programs, business methods, vendors, anything that gives the company a competitive edge. Protecting a trade secret requires maintaining secrecy rather than official filing process for protection. You really just have to keep it a secret and go through certain measures to keep it that way. Trade secret protects against misappropriation, theft, and purposeful or careless revelations. So as long as you can show that you took the measures to protect what you're seeking to protect, you will have these protections. A lot of times you may have an employee at your company and they go rogue, or they get fired and they get mad, and they take your secrets, to the competitor or to another company. Now you have an action for the trade secrets being misappropriated. So you have to maintain the secrecy, like I said, and there are various ways to do this. Diligent policies, contracts, non-disclosure agreements. You have to identify the trade secret. It has to be marked, restricting access to certain areas where the trade, where the thing that's secret, only people who need to go back there, only people who need to know these things have access, secure spaces, visitor logs, so you can keep a track on who's going around these things. So if it does get misappropriated, you have some idea of where to look first. And so that's generally, how trade secrets work. I always tell people, when they go on for patent protection to first look and see if it's something easy to create versus, not to determine whether you keep it as a trade secret or to seek patent protection. And so that's the general, 4 types of IP. The second part of this discussion is about how IP is important to entrepreneurship. And it's important in various ways. One, there's always other companies out there that are looking to increase their bottom line, looking to build on what they're doing. And a lot of times they look to entrepreneurs and startups for fresh ideas. And so it's important and it's imperative that whatever we create, whatever we, think would be valuable to us, to our company, to our families down the line, that we seek some type of protection for those things as we build and create. Another important reason that IP is important for entrepreneurs is that when you're going through various stages, so say if you're seeking funding or, from venture capitalists or from angels or, whoever, they're going to want to see what kind of competitive advantage you have over others within this industry. One key thing that investors love is that you have IP protection or that you've at least filed for IP protection. It shows them that you know what you're doing. It shows them that you're going in the right path to do these things. And it shows them that if we give you our money, that you'll be able to continue to build what you're doing without the risk of others trying to come in and take what you're building. So that's very important when it comes to entrepreneurship and IP. And it also gives you a sense of completion, a sense of accomplishment. I remember when we first started, there are going to be times where, it's going to be good days and bad days. It's going to be ups and downs. And this is one milestone that you can, take anywhere with you. And a lot of entrepreneurs are proud to get any type of IP protection because it shows that what you're building is valuable. It shows that it's important. It shows to the world that you took the time to do these things. And so I always tell people that as soon as you can, at the earliest stages, look at different parts of what you're building or what you're creating and determine which type of IP protection you can seek to protect those things as you move forward. Because the vision or where you start is never the vision of where you want to go. So you might think it's not much now, but your vision of where you want to go, that thing is going to be very important. It's going to be a building block to get you, from point A to point Z. So always look for the best way to protect these things. If you can't afford it, there are vehicles out there to assist you. And for example, my goal is to not have any entrepreneur that can't seek these protections. You want to, like I said, you want to put everyone on an even playing field. You want to make sure that the big companies can do what they need to do. And you want to make sure the entrepreneurs and startups can do what they need to do, and not just battling against each other because many times it doesn't end up being competition. It ends up being partnerships born from this, or mergers or acquisitions or something like that, where the bigger company sees the value in what you're doing, and you can negotiate better with them if you have a patent on something, that they can use, or if you have a trademark, or whatever it is, you'll be in a better position to go to that, to go to that table, to do what you need to do as an entrepreneur, as a founder, and get to that point, So that's what I have today for you guys for IP, for entrepreneurship. Like I said, my email address is james@ipgen.il. If anyone has any questions, I'm always good with talking to entrepreneurs and founders about things because I had to have much help throughout my journey as well. So, whoever, have a couple questions, shoot me an email. We'll set up a time to talk. And I want to see all of us reach the potential that we deserve, that we get to where we need to be. And if I can help in any way, I will. So thank you for having me today. I hope that this information resonates with some people. Like I said, contact me if you need me. Thank you.
Thank you so much. That was a great presentation. And if you have just a minute, we have some questions in the chat. I will get those and you can answer them for people. One thing was that we had a few people who wanted to have your email to be able to contact you. So
Yes, you can put that in the chat.
throw that in the chat for everybody.
Yep.
And then we did have some questions
Okay.
in the chat while you were talking.
Okay.
And so we did have at least one or two inquiries about people who were interested in being able to talk to you about things related to all of this information. So
Right.
they have your email now, but also some other questions. One question was, what advice do you have for artists releasing information on different platforms?
Okay. And there are a bunch of there are a bunch of platforms out there, and by artists, I'm going to assume a musical. I'm a musician, but this would go across if it's if it's an artist, a painter, or anything. You want to make sure that you get that copyright protection, if possible, before you release, whatever you need to release on these platforms. I know, like Spotify, Apple Music, if it's a musician, there are benefits in having, these things to have copyright protection. And there are different levels, there are different types of things that you can protect, like the words, the actual music behind the words, the composition, and things of that nature. And so if you, whoever had that question, if you want to reach out to me, we can go into more detail about, the types of things that you could protect through copyright protection. But you definitely want to have that protection as you go and present your, what you have to the world. You see all the time that these mainstream artists are into it with these people coming up. Like, they'll have one song, there'll be a post with one song playing from the mainstream artist, and then they'll have the up and comer song playing, and it's very similar. And so, but that person might not have had copyright protection, so the damages that, I'll say federally protected copyright protection. So the damages that they can get from that will be, minimal, as as if they had copyright protection from the Federal Register. Yeah, so just contact me if you want to go further.
So another question that we had was, can individuals research a list of existing copyrights to avoid infringement? So is there a good place to go look up existing information to make sure you don't end up having a problem?
So there are, and this is with all IP, there are databases at the USPTO where online from the USPTO, copyrights with the Library of Congress. I know they're supposed to be merging with the USPTO. I'm not sure if it's been done yet, but yeah, there are places to search for these things for registered copyrights.
So we're going to take a question from the room. So I'm going to pass the microphone over here so everyone can hear all.
Yes, my question is this. One thing is to get this copyright and trademark. The other thing is to monitor and to go after the people who infringe on your rights. What is the best way to have a constant monitoring service to monitor it, and also how to stop them?
So to monitor, you can do simple searches online, general searches online, and you can, if your company is large enough, you can have people, to be constantly doing that. You could, if you're savvy enough, you could, create a computer, a small computer program to monitor certain keywords or certain things that may appear on the internet. Those are ways that you can monitor it to take action. You can reach out, you can do cease and desist, You can contact them to, try to license what you have. And then, finally, you can, take the person to court. You can, you can file suit. the thing about going to court, a lot of larger companies, have more money than the average entrepreneur. So, you want to be careful with how you maneuver. Um, it may be best to try to settle things out of court, and they'll try to move it to that direction. You have to be vigilant. You have to make sure that you're getting from the deal what you want to get from it. And if not, take it to court and see how it shakes out in court. You may have to hire an attorney. Some people do it pro se on their own. But there are vehicles that are, different things to help people who don't have the capital to go after those who may be infringing on, a certain IP that you may have.
So you had talked a little bit about how entrepreneurs and big business, how they can end up interacting with each other.
Yes.
So one question we had was, how can we address equity for small business in patents? And does IPGen do something that actually helps in this process?
Could you repeat that beginning part one more time?
Sure. How can we address equity for small business in patents? And how does IPGen help with that?
So addressing equity, now if it's so I'm gonna go two ways here, because I'm gonna go one way just within your company, equity, and then one way if you do, go into that partnership with the bigger company. The equity within your company, like if you have multiple founders, if you have first key hires that are very important to to what you're building, to your company moving forward, you would distribute equity. The founder, their CEO, may do that at first if they're by themselves, but if it's a group of people who are coming together, you want to make sure that you define that equity and those roles within the company at an early stage, so everyone is comfortable with what they have. For example, if it's 4 people, it might not be 25% across the board, because the value that one person brings to the company may be more than another. So you want to make sure that you divide that equity based on the value that that person would bring to the company. And that goes to what they're building, as it goes to patent. Now, if it's a startup, if it's an entrepreneur who's sitting at the table with a larger company, and we're using a patent to drive this conversation, you have to look at a variety of factors. One, are they trying to get an exclusive license or not? You have to look at if they're trying to acquire you, if they're trying to, if they want you to merge. There's a lot of factors that go into that is case specific, and that's something that I can discuss with you, on a one-on-one, but I would need more information, to kind of let you know the best way to structure, the equity, because sometimes acquisition or sometimes acquisitions are just stock, sometimes it's cash and stock, sometimes it's all cash. So if you have something that's patented and you're in that situation now, definitely feel free to reach out. We can go over the specific facts of that case to see how it's best for you to move.
So we had a question about what type of support do you wish was in place to help you as an entrepreneur when you started?
Well, it kind of helped that I was an attorney before I started. I was able to do a lot of our contracts, our IP stuff, and a different, and various business documents and things like that. So the biggest thing for me was the capital to build. A lot of founders, a lot of entrepreneurs run into issues where, you know, if you didn't save up, if you didn't save up a bunch of money, or if you didn't have, you know, family and friends who have a bunch of money stored away, those early stages are difficult. And so my wish is that as time goes on, those dollars are better, you know, put to where they deserve to be from these entrepreneurs that are grinding, you know, because this is the heart, small business and entrepreneurship is the heart, it's really the heartbeat of the country. Is where that innovation comes from. And we need to foster that here. So I really, and there are companies that are doing, you know, things about this, and, you know, venture firms that are trying to get money to earlier stage companies. I'd be remiss if I didn't mention how TEDCO has helped us in the early stages with, you know, with capital and resources. That's a Maryland arm, but, you know, there are various, and, you know, whatever state you may be in, there's similar, you know, vehicles for that. You have to do your research, but, you know, if you can find those people to kind of, you know, supply that capital, those resources, and it's not always capital, you know, it might be something that you don't know. So if you could get a resource here and there, I think that goes a long way to help you to get to those early stages.
Are there any additional questions online or in the room at the moment? Okay, so my question is, how do you see things changing over the course of the next 5 to 10 years? And what do you see as your position as things change?
Over the next 5 to 10 years, I, I believe the world is going to look a lot different than what it does right now with artificial intelligence at its head. There's going to be many positions that can be done by artificial intelligence. And there'll be some that people will try to, you know, to try to make the artificial intelligence do, but won't be able to get done. But I do think that, you know, the world will look a lot different. And some people might not like that. Some people might think that's a negative thing. I tend to think it's positive if we keep it within a certain, you know, confined space. If we keep it regulated, I think that we'll be able to use these technologies, and not just AI, but others, to further the world. It'll even create jobs. It'll take some, but it'll create others. And I see IPGen, you know, the vision that I have for our company is that any type of IP work that would be done on our platform. You know, it'll be streamlined directly, you know, to the government, and it'll make these processes easier and quicker, that the average person can do it with minimal or no help. So that's my goal, and I know that, you know, once you get enough capital, you know, you probably won't want to do your own IP work. So that's why we have tools and things for the lawyers, so the lawyers will be able to work with their clients on our platform. University tech transfer and commercialization, that's actually our next release that'll be in August. We're already started working with some universities now in that space, but our next release of the platform with those features will be released in August. And so just as we continue to grow and to build, you know, we want to make sure that we all get the proper protection that we need, and that protection is quality. And also, you know, we want to make sure that the entrepreneur's journey is smooth along the way. So, you know, there'll be other features on the platform other than IP, like, you know, freelancers for these entrepreneurs, investors on our platform so they can see these companies at this early stage so they can invest early in these companies that are grinding and putting in the work. So, just we want to see the world in a better place than where it was before.
So I was looking, I don't see any additional questions online at the moment. No more questions in the room. So I just wanted to thank you for coming and speaking.
Thank you for having
We
me.
appreciate all the good information. And thank you, everybody, for attending here and in Zoom. I hope everybody has a good evening. We'll see you next time.
Thank you. Good night.